Dear students, I welcome you on behalf of Thakur Vidya Mandir High School and Junior College for the remote teaching learning process, where our motto is let learning be a joy and teaching a pleasure.
Dear students, let us move towards part 2 of chapter number 5, that is deposits, wherein today we are going to continue with the terms and conditions relating to acceptance of deposits. Let us continue with question number 1, that is explain the terms and conditions for acceptance of deposits. In our previous video, we have already understood about the 5 conditions which are necessary relating to acceptance of deposits. That is, we learned the amount of deposit which a private company, a public company other than eligible company, eligible public company and government company can accept. Second, we also learned about the period or the tenure of deposit. Third, we learned that a company cannot accept demand deposit. We also learned about the secured and unsecured deposits which the company can accept. And lastly, we also understood that company needs to provide application form for accepting, that is inviting the deposits. Let us now continue with the next terms and conditions relating to acceptance of deposits. The sixth condition is relating to joint names. The Companies Act specifies that a company can accept deposits in joint names of depositors. That is, the depositors could be more than one, but there should not be more than 3 names. The next condition is related to the nomination facility which is available to the depositor. The company's rules states that every depositor at any point of time has the right to nominate any person as nominee of his or her deposit. Nomination facility simplifies the procedure for settlement of claims in the event of death of depositor. The next condition is related to circular or advertisement. In our previous video, we have already learned that a company can accept deposit from members or public depending on the type of company. That is, whether it is a private company, public company, eligible public company or government company. Thus, the Companies Act states that if a company invites deposits from its members, then it must issue a circular. But if it invites deposits from general public, then it has to issue an advertisement. There are several rules to be followed in case of circular or advertisement. Let us now move towards the same. The first one being the contents of circular or advertisement. A company accepting deposit needs to include the following contents in its circular or advertisement. Firstly, it must include statement about financial position of the company. Financial position is nothing but the balance sheet of company. This financial statement includes 3 main components, that is, it speaks about the assets, liabilities and equity of the company. Secondly, it needs to mention about the secured portion and the unsecured portion of deposit. Thirdly, an eligible public company also needs to specify the credit rating which it has obtained from the credit rating agency. Next, it also needs to provide complete details of the deposit scheme. Further, Under the Companies Act 2013, appointment of deposit trustee is mandatory for the companies raising secure deposits, and the circular or advertisement need to mention the name of such deposit trustees. Lastly, the company also needs to state whether it had accepted deposits in the past or not. If accepted, then what is the amount which is still due towards such deposits? The next rule is relating to filing of circular or advertisement with Registrar of Companies. A company needs to file a copy of circular or advertisement with the Registrar of Companies. However, before filing, it must be signed by all directors of company. After filing copy of circular or advertisement, the company can now issue circular or advertisement to members and public respectively, but it can do so only after 30 days of such filing with Registrar of Companies. Now, if the company invites members, then in such a case it can send circular through registered post, email, etc. However, if it invites public, then it must publish advertisement in one English newspaper and one vernacular newspaper in the state where the company's registered office is situated. The last rule relating to circular or advertisement speaks about the validity of circular or advertisement. The circular or advertisement is valid for a period of 6 months from the end of financial year in which such circular or advertisement was issued, or date of annual general meeting. Out of this, whichever is earlier, it will be valid for that particular period. Let us now move towards the ninth condition relating to acceptance of deposits, that is, appointment of deposit trustee. If a company issues secured deposits, then eligible companies and public companies need to appoint at least one or more deposit trustees. Just like debenture trustees protect the interest of debenture holder, in a similar way, the deposit trustees protect the interest of depositors if the company fails to pay the deposit amount back to the depositor. Further, while accepting deposits, the company also needs to enter into a contract with deposit trustees, which is called as trust deed. This trust deed contains terms and conditions of contract, and it must be signed at least before 7 days of issuing circular or advertisement. The next condition speaks about creation of charge on assets of company. If a company accepts secure deposit from public, then in that case it needs to create charge on tangible assets of company, and that too within a period of 30 days from the acceptance of such deposits. Further, the amount for which charge is created should not be less than the amount of deposit which is accepted. The 11th condition is related to deposit insurance. Rule number 5 of Companies Acceptance of Deposits, Rule 2014, speaks about deposit insurance. It states that the company inviting deposits must enter into a contract for providing insurance to the depositor. It is compulsory for companies to take deposit insurance if the amount of deposit plus the interest on such deposit is up to rupees 20,000. Further, company needs to take deposit insurance at least before a period of 30 days from issue of circular or advertisement. Insurance contract must specify that if the company makes any default in payment of principal amount or interest thereof, then the insurer will be liable to repay the amount back to the depositors. The 12th condition speaks about obtaining credit rating. Just like an issue of debentures, even in case of acceptance of deposits, a company must get its deposit credit rated from credit rating agency. The credit rating so obtained must be included in circular or advertisement inviting the deposits. Further, while giving rating, credit agency considers the following aspects. Firstly, it takes into consideration net worth, that is, the difference between assets and liability of company. A high net worth relates to good financial strength and ultimately good credit rating for a company. Secondly, it considers liquidity position, that is how easily company can convert its assets into cash. For example, assets like stock and bonds are very liquid since they can be easily converted into cash within days. However, large assets such as property, plant and equipment are not as easily converted into cash. Lastly, the credit rating agency also considers the ability of the company to repay the deposits on time. After taking into consideration all these factors, then only the credit rating agency provides the necessary credit rates to the company. The 13th condition is related to opening of deposit repayment reserve account. A company accepting deposit needs to open deposit repayment reserve account with a scheduled bank. Scheduled bank are those which need to satisfy certain criteria as laid down by Reserve Bank of India, and also they enjoy certain facilities. Some examples of scheduled bank in India includes State Bank of India, Dena Bank, etc. Next, the company needs to deposit an amount which should not be less than 15% of the amount of deposits maturing during the current year and the following financial year, that is the next financial year, and that too on or before 30th April every year. Lastly, the amount which is accumulated in this account must be used only for repaying deposits. The 14th condition is related to issue of deposit receipt. Further, a company needs to issue deposit receipt to depositors as an evidence for the amount which they have deposited with the company, and that too within 21 days from receiving deposit money, and in case of check after realizing the amount of check. This deposit receipt contains the following details. It should specify the names and the address of the depositor, the amount of deposit, that is whatever amount they have deposited with the company, the rate of interest which would be paid to them, and also the date on which the company will repay the principal amount back to them. Let us now move towards the 15th one, which is register of deposit. The company needs to maintain a register called as Register of Deposits at its registered office. The company needs to enter detail of deposits as well as complete detail of depositor in the register of deposits within a period of 7 days from issuing deposit receipt. 16th is related to return of deposit. The company needs to file return of deposit with registrar of companies to provide complete information about deposits. Such return must be filed on or before 30th June every year. The 17th condition speaks about the interest which is paid to the depositor. The company's rules states that the maximum rate of interest which a company can pay depends on the guidelines given by the Reserve Bank of India from time to time. A company cannot pay more interest than specified by RBI. Further, if it makes repayment of deposit before maturity date, that is premature repayment of deposits, then it has the right to deduct 1% interest from the rate of interest which the company had stated at the time of acceptance of deposit. The 18th condition is related to right to alter, that is bring about changes in the terms and conditions. The Companies Act further states that a company accepting deposits cannot alter, that is, it cannot bring about changes either directly or indirectly in the terms and the conditions of deposit. No changes can be made even in deposit trust deed, and even no such changes must be made in the deposit insurance contract. Lastly, these changes should strictly not be made once circular or advertisement is issued and the deposits have already been accepted by the company. The next is related to disclosure to be made in financial statements. The company needs to disclose in financial statements about the money which it received from directors, relative of directors in case of private company. Financial statements are the formal records of financial activities and position of company which provides relevant and important financial information in a structured manner and in a form which is really very easy to understand. Let us now move towards the last and the 20th condition which is related to punishment. The Companies Act specifies that any officer of company who makes default and goes against the provisions of the Companies Act is punishable for such a fraud made by him or her. Further, in order to protect the interest of depositors in the state of Maharashtra, the state government has passed Maharashtra Protection of Interest of Depositors Act 1999. It states that companies in Maharashtra will be punished for contravening, that is going against the provisions of this act also. So with this we have completed all the 20 conditions related to the acceptance of deposits. Thank you students for your patience listening.